Okay, we're back in order, and your microphone.
Mr. Chairman.
Make sure it's on.
It is on. Am I close enough?
Yeah, you got to speak up.
Thank you, Mr. Chairman. Commissioners, my name is John Challey. I represent SC DN in this case. Mr. Jones, good afternoon.
Good afternoon. I would say it's good to see you, but that would be a lie, and I'm sworn to tell the truth.
Fair enough. Fair enough. So, as you just alluded to, we met during your deposition, which was held about 3 weeks ago. Isn't that right?
Yes.
Okay. And Mr. Jones, during your deposition, we discussed a number of things. I'm going to go over a handful of those. First, we discussed that in your career, you've worked on a handful of nuclear projects in various phases. Isn't that right?
You may classify it as a handful. I classify it as a pretty stellar record.
Fair enough. You said during your deposition that you identified 4 different nuclear construction projects in which you had previously been involved. 4 construction projects, I said.
Yeah, I think one of those was kind of an extension on Watts Bar Unit 1, but 3 involved definitely in the hard shell construction stages, and the other was the Watts Bar Unit 1. Yes.
Okay. So that's 4. Isn't that fair? 4 projects in which you were involved, 4 projects of nuclear construction, 4 nuclear construction projects in which you were involved.
Yes.
Right. And then you also said that you were involved in 2 projects that were restarts of nuclear reactor facilities. Isn't that right?
That's correct.
Okay. And you, during your deposition, equated those restarts with construction of nuclear reactor facilities. Isn't that fair?
I didn't equate them with it, but I said that there's very similar circumstances to it. The plant is basic. It's an operating plant that's shut down. It has to go through a lot of modifications that require construction work, and it has to go through improvements in both quality assurance and operations in order to come back online to get the NRC approval to do that.
Okay. So that's 4 nuclear construction projects, 2 restarts. Isn't that right?
Yes.
Okay. And of those 6 total projects, 3 of them were either abandoned or had come to a point where they were no longer operating, and a 4th project, which is Watts Bar, was embroiled in a decade's worth of construction problems. Isn't that right?
I don't recall telling you 3. Marble Hill Units 1 and 2 were abandoned, and I don't know what you're talking about, the other one.
Okay, let's go through them specifically. One of those projects was Marble Hill, as you just alluded to, right?
Correct.
And you came onto the Marble Hill project as the project manager at the start of construction, correct?
Project manager for Sergeant Lundy, in charge of the architect engineering work on the project, yes.
Okay, and 4 years into construction, Marble Hill was abandoned, wasn't it?
I don't remember the exact dates of how long it was into the construction, but the project was abandoned in a partially completed state.
Okay, abandoned because of construction quality issues and because the utility could no longer afford to complete the project. Isn't that right?
I think that's a fair characterization, yes.
Okay, and then you also talked about the LaSalle County plant, which is one that you were involved with somewhat early in your career. Isn't that fair?
Yes.
Okay, and LaSalle County actually went out of operation for a period of time, correct?
It was one of the restart plants that I talked about. Several years after I had left LaSalle, they got into operational issues with the NRC, and there was an order that shut the plant down and had to have a restart effort in order to come back into operation.
Had to shut the plant down because of quality issues, right?
There are a number of reasons for the shutdown. It was primarily that they hadn't done a good job in keeping up with the NRC changes that came out of 3 Mile Island, the 3 Mile Island accident. So there was a lot of modifications that needed to be implemented on the plant. They had operations, quality issues. So those were the primary reasons that it got shut down.
Okay, that's right. You told me during your deposition that it was shut down due to quality issues, right?
That was part of it, quality of the operations. Yeah.
Okay. Then you also referred to a D.C. Cook plant in which you were involved, right?
That is correct.
And that D.C. Cook plant was shut down for similar reasons, wasn't it?
Yes.
Okay. And then you said you were involved with Watts Bar.
Yes.
And you're familiar, are you not, with the decades worth of construction issues that embroiled the Watts Bar project?
Yes.
All right. So just to get a little bit more precise there, the Watts Bar plant did not come online until 10 years after you left the project, and that was because of continued issues with construction at the plant site. Isn't that right?
That is my recollection. I wouldn't attest to that precisely, but it was a long, long time before Watts Bar Unit 1 became operational.
Okay. You told me during your deposition it was 10 years.
That's what, and I think I caveated it the same way.
All right. So you would agree with me, would you not, that constructing and maintaining operational nuclear reactors is extremely complicated, right?
I would agree with that, yes.
Events that may occur that make completing construction of a nuclear plant just not feasible.
How did
that
we
right?
get from operating plants to construction? I didn't follow your line of reasoning there.
You said all the way from construction to operating a plant? I'm confused. Let me just ask the question.
I thought you asked a question about operating plants. Operating a nuclear plant is difficult and complicated. I'm sorry if I misunderstood your question.
No, what I said was you would agree with me, would you not, that constructing and maintaining operational nuclear reactors is extremely complicated? Constructing and maintaining operational.
Yes.
Okay. And that's because events may occur that make completing construction of a nuclear plant not feasible at all.
Events may occur. Okay, yes, events may occur.
Right. And of the 6 projects in which you have been involved throughout the history of your career, more than half of them experienced those problems, right?
Oh, yes. One of the primary reasons I was involved in some of them was because of that, yeah.
Okay. So it's not at all uncommon then for a nuclear construction project to face substantial challenges, is it?
No.
Okay. Now let's talk about the VC Summer project. You were hired by ORS to consult on construction of the VC Summer nuclear reactors units 2 and 3, weren't you?
No. I was hired to monitor the construction and construction schedule and budget.
Okay, so yeah, so you monitored both the construction and the budget for the project, isn't that right?
Yes.
Okay, and it included, your work included whether SCE&G had strategies and plans in place to be able to meet the construction and cost schedules for the project, right?
As part of my duties, I would review the mitigation plans and strategies that SCE&G developed and presented to me as how they were going to fix the various issues on the project, yes.
For both construction and cost issues, right?
I mean, if you take cost issues all the way to how you're going to finance the project, no. But in general, those costs of construction associated with doing the construction on the site, yes.
And you took your responsibilities seriously, didn't you?
Yes.
And in carrying out your responsibilities, you had access to the actual project site, didn't you?
I had access periodically, as I've said before, as a visitor with escorted access, yes.
You had periodic status meetings with SCE&G managers and others on the project site, right?
I did mostly once on a monthly basis, not strictly on that basis. Sometimes it was more, sometimes it's less, but generally throughout the history, it was a monthly basis of meetings with the senior managers involved in the plant.
When you needed that access and when you needed those meetings, you were able to get what you needed, right?
We thought so.
Okay. So you also reviewed documentation related to the project provided by SCE&G, didn't you?
I did.
You would agree with me that SCE&G provided the Office of Regulatory Staff and you specifically with information related to the project quarterly, monthly, weekly, and even daily?
Yes, and it wasn't all information all the time, but yes, we got daily reports that basically were the plan of the day meeting notes. We got weekly reports, which were weekly construction status, and monthly reports, which were meetings with the consortium and with other groups, and then the quarterly report was presented in a written form as required by the BLRA.
Okay, so you are aware, are you not, that an ORS employee, Gene Solt, attended plan of the day meetings, right?
Yes, Gene did not attend all the plan of the day meetings, but he quite frequently attended plan of the day meetings, yes.
And when he did, he reported to you on what he learned during those meetings, right?
If there was something significant, he would bring it up.
Okay. And I believe you said you reviewed weekly construction status reports as well?
In general, that's the case. I can't say that I reviewed every weekly construction status report. I would definitely review the ones, the most recent ones, in preparation for my meetings on a monthly basis with SCENG. So I did have access to, but did not necessarily review every weekly status report.
And if you didn't review it, it's because you concluded you didn't need to review it.
No, I concluded that for my purposes in being able to discuss the issues with SCENG, my review of the most recent report would be satisfactory.
When you say wouldn't be satisfactory,
Would be satisfactory, I said.
would be so it wasn't needed for you to review those weekly reports in more detail.
In my opinion, no, it wasn't necessary, but they were available, and in some cases, there were specific issues that were identified by my colleagues that did prompt me to go back and look at the ones on the interim basis.
We talked about some other reports that you reviewed during your deposition. You reviewed BLRA milestone tracking reports, right?
Yes.
You reviewed SCENG's commercial issues log, didn't you?
Yes.
You received status reports directly from the consortium members, didn't you?
Directly from the consortium. Yeah. Well, if you're talking about the meeting minutes of their meetings, their monthly meetings, yes.
Okay. And you reviewed project review meeting minutes as well, right?
Yes. That's basically what I was talking about there, I think. So, yes.
And periodically you reviewed schedule reports as well, right?
Yes. The weekly construction reports usually had the 90-day look ahead and the 2-week look ahead schedules appended to them.
And you reviewed some of those schedule reports on what you described as a very complex piece of software, right?
No.
You did not?
No. The reports were presented to us in hard copy and reflected what the next 90 days of the projects were going to do and what they were going to do in the next 2 weeks. There were occasions where we, in fact, did have meetings with the scheduling people. And we would go into a room where they were running the program, and they would present to us, usually, the critical path, go through the critical path, bring it up as you say, the complex program, or in some cases there were special things that we would ask them to do. We did not review the entire schedule, which would have been impossible. It had, I believe that both units had around 500,000 entries on them. So usually it was what we requested to review.
You said that you were aware during your time on the project and before abandonment that the schedules were extremely complex, and you said have over 500,000 different specific, what would you call them, milestones?
Activities.
Activities. They had over 500,000 specific activities, right?
Yes.
And you're aware that Westinghouse was primarily responsible for preparing that particular schedule?
Yes.
Okay. Now, you also reviewed risk and mitigation reports, right?
Yes. Those were provided to us also on periodic basis, and we would review those also.
Let me ask you, Mr. Jones, going back to this 500,000 activities, have you been involved in a nuclear construction project that ever had a schedule with over 500,000 unique activities?
Probably not 500,000. Well, that's for 2 units. I have been involved with nuclear projects that have over 100,000 activities in their schedule, maybe up to 200,000. But I think this one was this one had more than I had seen previously. But I would say that the whole discipline of project scheduling has evolved also, and the tendency has been to go more and more and more detailed in order to get a better handle on the project schedules.
We've heard a good bit about productivity reports since the commencement, or productivity specifically since the commencement of this hearing. You received monthly productivity reports, didn't you?
Those were part of the construction reports that we got. The productivity would be reported on a monthly basis, usually I would say, a month lagging basis, we'd get the productivity report for the preceding month.
And that productivity report would reflect specifically the productivity factor on the project, right?
Yes, there would be individual productivity factors for craft, for in some cases it was for commodities, and then overall productivity, yes.
So now, over a year after the abandonment of the project and having participated in discovery with the ORS for a significant part of that time, when it comes to productivity factors on the project, are you aware, you are not aware, are you, of any productivity factor information that you were not provided?
I'm not aware of any productivity factor information I was provided, unless you include the productivity factor used in Ms. Walker's, the EAC analysis done by, led by Ms. Walker. We were not privy to that.
Did you know what the inception to date productivity factor was in late 2014?
The inception to date wasn't as important to me as was what had been done in recent months. So I probably was aware of it, wasn't in the forefront of my mind.
Did you know the productivity on the project in 2014 and in 2015?
I knew it at that time. I do not know it now.
But you received in real time information, and I believe you characterized it as your deposition as you were not aware of any productivity factor information that I didn't receive. You would agree with that, right?
Now, with the exception of Ms. Walker's productivity factor information, I would agree. I'm not aware of any. And
when you say Ms. Walker's productivity factor information, you're referring to the assumptions that you understand she used. Isn't that right?
That is correct.
Okay. During your deposition, I think you summed it up by saying that the ORS received many, many reports from SCENG. Would that be fair?
Oh, yeah.
Okay. So let's just make sure we've got a cast of characters from the ORS. In addition to you working on the ORS, Ms. Allen Powell and Gene Sult were consistent members of the ORS team working on the project, weren't they?
That is correct.
And they also had access to the construction site just as you did, correct?
Access to the construction site under the same conditions, yes.
And the various forms of information about the project that you had, isn't that right?
Yes.
And the three of you freely shared information related to the project, didn't you?
Yes.
Okay. Mr. Jones, you're here on behalf of ORS to assert certain opinions, but I want to be clear. I think you are saying you only challenge costs the owners incurred on the project after March 12 of 2015. Isn't that right?
Yes.
Okay. So as to activity prior to March 12, 2015, it's your testimony that while there were challenges associated with the project during that time frame, and I'm quoting now from your pre-filed testimony, each of these challenges had potentially workable solutions and mitigating approaches which were pursued and implemented at varying levels. Isn't that right?
That is the case. I have found no additional evidence in the discovery process that would lead me to change that opinion.
And you continue to say in your pre-filed testimony that the potential solutions proposed at the time for certain challenges that arose related to the project appeared to provide a viable path forward that would result in a successful and economical project which would have benefited the utility and SCENG ratepayers, right?
Yes, at the time it appeared that these mitigation programs would do that. Unfortunately, in almost every case, they never did.
You would agree with me that these pre-March 12, 2015 issues were disclosed to the ORS, correct?
I think that's too broad. I think we were aware of, I believe, most of the significant issues on the project. I would not deny that we were aware of the issues of the project. That is true.
Nor would you deny that the commission, through testimony of many people, including you, were also aware of those issues.
I wouldn't say we conveyed all the issues to the commission. We conveyed those that we thought had the the most impact on the schedule and the budget. That not all issues were conveyed to the commission, nor do I think they needed to be.
So you're not aware, sitting here today, of any issues that existed prior to March 12, 2015 that weren't disclosed to the commission?
No, I'm not aware of. Well, again, it's not any issues. I think the commission was pretty well informed of those issues that could have the most impact on the budget and schedule.
Fair to say that there was no material information that you know not to be disclosed?
No, it would still be material. It's just that it's not something that necessarily the commission needs to know about if it doesn't have much impact on the budget and schedule. It could still be a issue that is important and is material. It just doesn't have that kind of impact.
But you don't have any issue with these pre-March 12, 2015 disclosures, right?
I have identified none at this time, no.
And none of those issues that existed prior to March 12, 2015, in your opinion, required a halt in the construction of the project or an immediate abandonment of the project, right?
I would agree with that. I've found nothing in my review that would have required abandonment or discontinuation of construction.
Okay, so I believe you said in your pre-filed testimony that the actions SCE and G took to address these pre-March 12, 2015 issues appear to have been reasonable based on the best information available at the time, right?
Yes, I mean, there were mitigation plans and approaches that were brought to bear on all these, and I think a prime example is eventually getting the module fabrication distributed to other vendors. That was a major benefit to the project, getting them out of Lake Charles and eventually to the point where Lake Charles had no role on the project. That was a big plus, and I think that was a good action.
Okay, so through all those twists and turns, your acknowledgement here that these actions were reasonable, these pre-March 12, 2015 actions were reasonable and based on the best information available at the time, would include your agreement not to challenge, for instance, the owner's selection of Westinghouse in the AP 1000 design, right?
Yes, that's correct.
Nor would it, also does it include, it also includes your acknowledgement as to the reasonableness of the EPC agreement and its structure.
Say again how you want me to address that.
You're not challenging here today any issue associated with pre-March 12, 2015 conduct that is connected to the EPC agreement and its structure.
No, I wouldn't say that, because one of the things that I point out is that I believe that in my testimony is that I believe the EPC structure there was basic flaws in that resulted in unnecessary and obstructive implementation of the project. I would say that the EPC contract would not be what I would say should go unchallenged. It was not a great agreement.
Let me say it more precisely then. Are you challenging any pre-March 12, 2015 conduct associated with the EPC agreement and its structure?
No. I mean, March 12, 2015, as I said, is my date, and I'm sticking to it.
Right. So as a result, you're not challenging any pre-March 12, 2015 conduct associated with the existence of a consortium of contractors as constructors as opposed to a single constructor, right?
I mean, in the general concept of having an EPC with a consortium, no, I don't challenge. And cost incurred prior to the March 12, 2015 date associated with problems with the EPC contract, I won't challenge.
Okay, so nor are you challenging costs incurred related to problems or delays associated with the issuance of the combined operating license?
No, I think, and I think that this was in my testimony. I think that those issues, unfortunately, were manifest in the design status of the AP 1000 as compared to the AP 600, which had been certified. That was a very important aspect of this whole thing. We had a certified design that had been approved by the NRC for a smaller reactor from Westinghouse, the AP 600. And the general consensus at the time was it wasn't going to be much of a deal to go from an AP 600 to an AP 1000. That turned out not to be the case with the NRC, so there were legitimate reasons the NRC delayed it, and reasons that Westinghouse was not prepared at the time necessarily to address those issues because they thought they would not be issues.
Now, you said that while it might not impact pre-March 12, 2015 costs, that certain aspects of the EPC contract you believe led to issues later down the road. Is that right?
I'm sorry, that kind of convoluted. Can you repeat that?
I can try. So you said that while you're not challenging pre-March 12, 2015 costs, you do believe that certain issues related to the EPC contract led to problems later after March 12, 2015, right?
Yes.
But you're familiar with an EPC contract structure, aren't you?
Yes.
And the fact that it's prevalent in the nuclear construction industry these days, right?
I wouldn't even say that. Most of the countries building nuclear plants are government agencies and don't have an EPC structure associated. China, for example, they're building their own plants. They don't have an EPC structure, and they're building more plants than anybody.
How about in the United States?
Oh, in the United States, there's only two. So, yeah, it's pretty prevalent.
Watts Bar was originally under an EPC contract structure, wasn't it?
Originally? When are you talking about?
Thank you. Watts Bar in the construction activity occurring since 2000 was under an EPC arrangement, wasn't it?
There was an EPC contract. I'm aware that there was an EPC contract, and that contract was with Bechtel at that time.
That's right. Bechtel was involved in Watts Bar, was it not? Are you familiar with the Office of Inspector General report related to Bechtel's work on the Watts Bar project?
I would not say no. I'm not familiar with it. I think in general I heard something about it, but I can't recall the details.
You know it was critical of Bechtel, don't you?
That I do know.
And specifically critical of Bechtel in that the owner for Watts Bar, TVA, had a more active role in the construction and management of Watts Bar than the Office of Inspector General believed would be appropriate.
Never heard that.
Never heard that?
Not aware of that.
Didn't know that at all?
No.
So if Mr. Ty Troutman, the president of Bechtel Bauer Corporation, testified to that fact, do you have any reason to dispute it?
No.
Okay. Now, you said one thing that you had recommended from the start on this project is that you thought it was appropriate to hire an owner's engineer.
Yes.
Okay. The fact that the owners didn't hire an owner's engineer didn't, in your view, constitute imprudence, but you said you recommend it. Isn't that right?
That's correct. I thought it would, and I think I said this before, would have been a best practice. Was it imprudent? Debatable. In my opinion, it wasn't imprudent at that time, but it would have been a good practice, and as it turned out, probably would have been a good idea.
Were you aware of the fact that Georgia Power hired an owner's engineer to assist in the Vogel project?
I'm not aware of that, no.
Okay. So but you are aware of the Vogel project, right?
Aware, yes. Detailed awareness, no.
And you are aware that the Vogel project right now is the estimated completion for the Vogel project is in excess of $20 billion, correct?
I believe the current estimate is $27 billion.
Right. So $27 billion cost, notwithstanding the fact that there is an owner's engineer.
Okay.
Okay. So now you do criticize the post-March 12, 2015 costs, in part because you claim that SCE&G did not disclose certain facts to the Office of Regulatory Staff. Isn't that right?
Yes.
In your rebuttal testimony, though, you admit that you were aware, I'm quoting, you were aware of many of the major issues on the project, right?
Yes. I have never denied knowledge of the issues.
And you also say in your rebuttal that you were aware of most of the major issues on the project, and that you were aware that these issues carried risks of impacting the schedule. Isn't that right?
That is correct.
Okay. But you still claim don't you, that SCE&G withheld material information from you?
Yes, I do.
And you base that opinion on two primary pieces of information, right?
Yes.
The first is, the first relates to the Bechtel report, isn't that right?
Well, this goes back, I think the two issues you're referring to, this goes back to before the Bechtel report. It relates to the hiring of Bechtel, bringing them on board to do an assessment.
Right. And second, you claim that SCE&G presented deficient and baseless estimates of the revised project construction schedule and cost for the 2015 docket, right?
Yes.
Okay. Now, before we get into those in detail, I want to talk to you about a presentation that you provided. Let me wind us up to get there. Mr. Jones, you take no issues with SCE&G's decision to abandon the project, right?
No, I really take no issues that the circumstances when they decided to abandon were, it should have been abandoned.
And you have no evidence to suggest that abandonment should have been decided on sooner, right?
No definitive evidence, no.
And you don't take issue with SCE&G's decision to monetize the Toshiba settlement?
Correct.
You agree that that was prudent?
Yes.
Right. So let's look at a document that I discussed with you during your deposition. It's Exhibit 17 here. Or excuse me, Exhibit 17 to your deposition. Let me get you a copy. We've got it projected on the screen, and Jillian will hand out. You recall this document, Mr. Jones?
Yes.
This is it's titled as a presentation made to the electric cooperatives of South Carolina, and your name is on the first page, is it not?
Yeah, I made this presentation to the cooperatives.
You made the presentation in March of 2016, correct?
Yes.
Okay. I'd like to tender this particular document as the next hearing exhibit.
Okay, this will be hearing exhibit number 20.
Okay, let's flip to slide 2, Mr. Jones. Okay, you would agree with me, Mr. Jones, that on this, in this presentation, you indicated that construction of units 2 and 3 was a very good idea in 2008. Isn't that right?
It certainly appeared to be, yes.
That's the title of this slide, isn't it?
Yes.
Okay. You then described some developments since 2008 that impacted the project, right?
Yes.
Despite those developments that you detail through this presentation, and they include the regulatory environment not as good as hoped, problems with modular construction, problems with certified design, you indicated on slide 5 that the BLRA remains an essential element to success. Isn't that right?
It certainly did. I mean, if the environment that the BLRA established wasn't there, this project would have never been authorized in the beginning, is my opinion.
Right. And the aspect of the BLRA that you believe is critical here is that it provides for recovery of financing costs as the project advances, and that creates certainty for the owners of this kind of project, right?
Yes, that was true at that time, yes.
Okay. And you also agree, as I believe you did during your deposition, that providing a prudency determination at the outset of a project gives certainty to owners about their ability to recover costs. Isn't that right?
I don't remember that. Could have been, but I don't remember that.
Okay. I'm going to hand you a copy of your deposition transcript. Project on the screen an excerpt from page 166 of that transcript. Specifically starting with line 9. And going through line 19.
Okay.
Mr. Jones, can you read that exchange in the record, please?
Question, but you understood that it was a good idea because it provided for certainty to owners of the sorts of nuclear facilities, correct? Correct.
Right, and then I asked you certainty as to their ability to recover costs, right?
Yes.
And then I also asked you, and that's critical to, that certainty is critical to incentivizing the construction and development of these sorts of facilities, isn't that right?
Yes.
Okay. And you agreed during your deposition that under the original BLRA, once costs were approved as prudent, SCE&G was entitled to continue to collect those costs regardless of whether there was abandonment, right?
Never got to that specific, or in my recollection, I don't remember that. In general, I agreed that the BLA was a good idea.
All right, let's look at page 169 of your deposition transcript.
Okay.
My question to you, let's just talk about your understanding about the original BLRA. Is it your understanding that costs approved under the BLRA were to the owners, or SCE&G, excuse me, was entitled to continue to collect those costs regardless of whether there was an abandonment of the project? And then what's your answer, Mr. Jones?
My understanding of the BLRA, is that yes, that's what's originally in the BLRA.
Okay.
Sorry, I thought you asked me if I thought that was a. You asked me my opinion of that.
No, but you understood that that's the provision of the BLRA.
Do you understand that's a provision of the BLRA?
And you say yes, you do. Is that right?
Yes. What?
You do understand that that's a provision of the original BLRA?
Yes, I do.
Okay. Now, I want to look at the second bullet under your, on slide 5, BLRA remains an essential element to success. That second bullet is an independent study shows the plant is still positive. See that?
Yes.
What specific study are you referring to there, Mr. Jones?
There was a study that was done by the ORS that basically looked along the same lines as Dr. Lynch's study. And I can't give you verse and chapter of that. Maybe one of my other ORS colleagues can, because I had very limited involvement in that study, but I know that it existed and it was done somewhat along the lines of Dr. Lynch's study.
Okay, so the ORS commissioned a study, and in 2016 you were aware of the results of that study, and that study suggested that, as the slide indicates specifically, that it shows the plant, as of 2016, is still a positive idea, right?
Still a positive idea based on the construction schedule, completion dates that we had at that time, yes.
Okay. And then on page 19 of this slide, you describe certain project challenges that you're aware of as of the time, right?
Yes.
Okay. And those are project challenges that you knew to exist, and in sum and substance, those are project challenges that you know were conveyed to the commission, right?
No, not all these were conveyed to the commission. For example, I don't think the commission ever heard of the shield building, air inlet tension ring, and roof design. Not all of these, as I said, were key items that needed to be brought to the PSC at the time that these were talked about. Certainly modules was a discussion at many of the PSC meetings. I know PSC was aware of those. To my recollection, I don't recall any specific discussions of startup or operations and support staff readiness that were presented. I may have faulty recall, but I know that the air inlet tension ring and roof design were not discussed with them.
But you knew all these things in 2016.
Yes.
And you had submitted testimony to the Public Service Commission in 2016, right?
Yes.
So to the extent you thought any of this information was relevant to the Public Service Commission, you had an opportunity to provide it then, right?
Sure.
Okay.
I had an opportunity to provide thousands of bits of information to the PSC. Did I think it was necessary? No.
Fair enough. Okay, so let's go back to these things that you feel like were not properly disclosed. First, let's start with Bechtel's assessment. It's correct to say that, in your opinion, the PSC in this proceeding should disallow costs incurred after the 2015 docket was opened, based in part on your belief that ORS should have been made aware of the fact of the Bechtel assessment, right?
That is correct.
Okay.
And I have explained why that is the basis of my opinion in my testimony.
Right. I would like to try to use your chart. It's a little difficult to read, but there's a couple things I want to point out on it. So give me a second. So it's difficult to read, and I'm not going to refer the commissioners to any specific language in the chart, but it's a timeline, is it not, Mr. Jones?
Yes.
Okay. I want to focus on a few things that you didn't include in your timeline. First, can you identify generally on this chart the early 2015 timeframe? Just point out, and maybe Mr. Willoughby could help us figure out where on that chart is early 2015.
2015 is clearly indicated where the little white band for 2015 is there.
There you go.
Go back to the little white band. That's where it starts, and the other white band is where it ends.
There you go. So that's 2015. So you knew in early 2015 that SCENG was considering an independent assessment of the project, right?
No.
Let's look at your deposition testimony. Page 79. Specifically line 25.
Make that a little larger for us.
I wonder if they could lower the chart so we could see
Or lower
the screen, please.
Yeah, Mitch, you want to lean the chart up against the table there, and maybe Jillian will get the easel ready and we can use that later? Thank you. So we're looking at page 79, line 25. I asked you, now Mr. Jones, you were aware in early 2015, and then we're going to the next page, that SCENG was considering an independent assessment of the project, right?
So you're on 78 and 80, right?
No, I'm on 79 and 80, the very last line of 79. And it's now projected on the screen in together. Might be easier.
Okay.
So you were aware.
Considering, yes. Okay. I would say considering, yes.
You knew in early 2015 that the owners were considering an independent assessment of the project.
What they The way I knew they were considering is that they asked me for recommendations on who would be somebody that could do that.
That's right. You said that Skip Smith asked your opinion on potential candidates for the assessment in early 2015, right?
Yes.
And you actually...
I would just like to clarify, that doesn't mean that they were going to do it. He asked me for recommendations on who would do it if they did it.
And you suggested Bechtel as one of the options, right?
I did.
So in early 2015, you knew, one, SCEG was considering the fact of an assessment, and two, that Bechtel was one of the options, because you provided that option.
Your definition of considering and my definition of considering may be entirely different things. I knew that they were looking at this as a possibility.
Okay. So you don't note on your chart that in early 2015 you had a discussion with SCEG about the possibility of hiring someone to do an independent assessment.
Gee, no, I don't put all of my conversations on that chart. No, sir.
Okay. So you are also aware, aren't you, that in August of 2015, Gene Solt, who we talked about earlier, was informed that an entity had in fact been hired to perform an assessment of the project.
I do not have a recollection of that, and we have had discussions on this, and I do not remember that at all. If Mr. Salt told me that, then he did. Do I remember it? No.
Let's look at the interrogatory responses the ORS provided in this case. Sorry, tab 5, Dan. You're familiar with these interrogatory responses, aren't you, Mr. Jones?
Familiar is probably too liberal a term. I have seen these.
You've seen them. So you know, do you not, that the ORS has admitted in these interrogatory responses that Gene Solt, in an August Plan of the Day meeting held on August 26, 2015, was informed, or excuse me, no, let me be precise about August. At the NND ORS monthly meeting on August 26, 2015, Gene Solt was informed that SCEG's legal office was handling an external review of the project, and at that time, it says Mr. Solt didn't know the identity of the reviewer.
Can you help us with a page reference, please?
Page 9.
I am generally aware that Mr. Solt has said that he had this discussion in August.
You have no reason to dispute what Mr. Solt is saying here, right?
I have no reason to dispute it, no.
Okay. You didn't include on your chart this August 26, 2015 information, did you?
No, I did not.
Oh, okay. You're also aware of the fact that the first meeting between SCEG and Bechtel to discuss the possibility of an assessment didn't occur until April of 2015. Isn't that right?
That date is on my chart, I believe, and if that's what it says, then yes.
Yeah, so you're aware that the first meeting between SCEG and Bechtel related to an assessment was in April of 2015.
Okay, I believe that is correct, yes.
Okay. And you're aware now that Bechtel wasn't actually hired to do the assessment until August of 2015, isn't that right?
Yes.
Okay. Let's look at the agreement between Bechtel and Smith Curry, the entity that actually engaged Bechtel. This is tab 6. You've seen this document in Discovery, haven't you, Mr. Jones? Can't read it from here. I don't know. You've seen it before, haven't you, Mr. Jones?
I think so.
Okay. And this agreement makes abundantly clear to you, does it not, that Smith, Curry, and Hancock engaged Bechtel Power Corporation, right?
Hold on just a second, please.
Sure. Let's just go ahead and...
I think I'm confusing this with the Bechtel proposal, which I had seen. I don't, when I look at this as the actual agreement, if we had, I'm not saying we couldn't have seen it since the development of the timeline, but I don't really now remember seeing this, and I think we would have put it on the timeline if we had seen it in time. So the Bechtel proposal I remember seeing, I'm not sure I remember seeing this agreement.
Mr. Jones, you would agree that the actual terms of the engagement of Bechtel are pretty critical, right?
Terms of engagement of Bechtel are pretty critical.
Well, your testimony in this proceeding is that certain facts related to Bechtel weren't disclosed, and I'm asking you whether you agree that the terms of the engagement of Bechtel are important to that analysis.
It's important to know what the scope of the work that Bechtel undertook was, and the extent of their assessment. Yes.
But you're telling me you've never seen the professional services agreement before. You can't recall.
Can't recall that. No.
Okay. But you would agree, just by looking at the first paragraph, which Dan will blow up here on the screen, that there's no question Bechtel Power Corporation was engaged by Smith, Curry, and Hancock.
I will agree that is ultimately how the contract was set, yes.
Right. And then in paragraph 1, Bechtel agrees to provide professional consulting services to...
Mr. Chairman, I object. I don't have a speaker. This document's not an evidence. Witness has not vouched for it, and counsel's trying to publish it into the record. I object. I hadn't laid the proper foundation.
Sustained.
Mr. Chairman, I would just note, I'm presenting this particular document for impeachment purposes, not for the purposes of introducing it into evidence.
Question to the witness was rude on Mr. Challey. The question of the witness was, are you familiar with the document? Witness says, never seen it. I would submit to you that's the end of the inquiry, unless he can lay the proper foundation.
I would just note, for the chairman's benefit and the hearing officer, Mr. Jones is testifying as to the significance of the Bechtel assessment in his view that SCE&G shouldn't be entitled to costs. And I think it's entirely appropriate that he be impeached in the sufficiency of that expert opinion on the clear and unambiguous terms of the professional services agreement between Bechtel and Smith, Curry, and Hancock. And the simple fact that Mr. Jones hasn't found this document in the production is no reason to exclude my questions to Mr. Jones on the basis of the agreement.
Speaking with Mr. Butler, hearing officer, we think he can ask questions, but with no foundation for entering it into the record.
Fine. We'll certainly enter this document into the record with the appropriate witness at the appropriate time. So, Mr. Jones, my question is back to paragraph 1. You would agree with me that this makes abundantly clear that Bechtel was providing professional consulting services to SCH, which is Smith, Curry, and Hancock, under the agreement. Isn't that right?
This document states that, yes.
Okay. And then later in that paragraph, Bechtel will perform the services with approximately 10 senior managers and anticipates completing the services in approximately
Mr. Chairman, we
8
have
weeks.
another objection. Documents hearsay is asserting it for the truth of the matter asserted. No one is here. Mr. Shelley's made perfectly clear this is not an SCE&G document. There's no one here to authenticate it. It's not a business record. He's clearly introducing it for the truth. What is in the document? It's improper. No exception applies.
I'm not asking Mr. Jones questions about the truth of this document. This document is being presented for impeachment purposes, which is entirely appropriate under the rules of evidence. It is not hearsay when it's presented for impeachment purposes.
Mr. Chairman, Mr. Butler, he specifically asked who signed the agreement and who entered the agreement. If that's not the truth of the matter of the document, there's nothing that is truth of the matter of the document.
Please.
It would appear to me that he can certainly ask him questions about what this document reflects. And that's all that Mr. Jones would be limited to. In other words, he can quote what's on this document. Certainly, it can't be admitted under the present circumstances for the truth of the matter asserted, but I do believe he can ask him questions about what this document says and then go from there. But I agree, I don't think it can be entered into the evidence at this point as evidence of the truth of the matter asserted.
Fair enough. I just have one more question on it, and then we can move on, make some progress. Mr. Jones, can you read paragraph 3 of this document, please?
Could be obstreperous and say, yes, I can read it, but I assume you want me to read it.
It'd be fine.
You're talking about the paragraph number 3. All communications related to the services between Bechtel or any attorney, agent, or employee of Bechtel on the one hand, and any attorney, agent, or employee of SCH or owner on the other hand, shall be regarded as confidential and made solely for the purpose of assisting SCH in giving legal advice to owner. Bechtel shall not disclose to anyone without written permission from SCH the nature or content of any such oral or written communication.
Okay, thank you, Mr. Jones. Then the last question on this document, page 5, indicates that it is signed on August 6, 2015. Is that, to your memory, the time when Bechtel was engaged in connection with this project?
I'm aware that Bechtel did come on site in the August 2016 timeframe now.
Okay, so the PSA, this professional services agreement, in your memory, regardless of what the agreement says, is that Bechtel was engaged 5 months after SCE&G submitted its March 2015 petition for updates to the PSC.
I'm aware that that's what happened. I'm not aware that that's what should have happened.
You're aware that Bechtel wasn't engaged until August of 2015?
That's what the document says.
Okay, and you're nevertheless opining that costs incurred from March 12, 2015 to the present should be disallowed by the Commission?
Yes, I am.
Okay. All right. Just 2 months after this PSA was entered in August, in October 2015, you yourself became aware that Bechtel had performed an assessment of the project, right?
Yes, I became aware that Bechtel had performed an assessment, not the scope of the assessment, the duration of the assessment, the conclusions of the assessment, or anything related to what they found. All I knew was the guy had stood up at the POD meeting, said, "We thank you for the assessment support that we got," put on a Bechtel hard hat, exited the meeting.
So let's be precise about that. Gene Solt attended a Plan of the Day meeting on October 15 where a Bechtel representative stood up, right?
Yes.
And and Gene Solt knew it was a Bechtel representative because he had a hard hat on that said Bechtel on the side, right?
No, I didn't know that until after he had made his thank yous. Then he put on a Bechtel hard hat as he was exiting the
But it was the hard hat that connected him to Bechtel.
Yes.
Okay. And then this Bechtel representative that stood up at the Plan of the Day meeting thanked everyone in the room for their assistance associated with the assessment. That's your understanding, right?
He made a general thank you.
Okay.
He addressed everyone in the room, yeah, because they were there, but I don't know if that implied that everyone in the room had some part in the assessment.
But Mr. Solt relayed this information to you, that he saw someone with a Bechtel hard hat, or at least before, later putting the Bechtel hard hat on, noting that Bechtel had done an assessment, thanking them for the assessment, or assistance in the assessment.
That's
Okay.
correct.
So within 2 months of the agreement executed between SCE&G's counsel and Bechtel, you became aware that Bechtel was on site conducting an assessment.
I became aware that Bechtel had conducted an assessment, and again, I repeat, not aware of the scope, extent, findings, or recommendations of that assessment.
But you didn't put the October 15, 2015 Plan of the Day meeting on your chart, did you?
No.
Nor did you put the specific agenda from the site visit that you created to request additional information related to the assessment.
Well, I didn't put it on the chart, but I certainly addressed it in my testimony.
That's right. So once you learned of the information Mr. Solt conveyed to you, you prepared an agenda item for one of ORS's monthly on-site visits related to the Bechtel assessment, didn't you?
Yes.
Okay, let's look at that. That's tab 7, Dan. You've seen this document before, right, Mr. Jones?
Yes.
This is an agenda that you prepared in advance of a site visit.
I did not prepare the agenda. I provided input to the agenda.
Okay, but you're familiar with the document, aren't you?
Yes.
Okay. You saw the document contemporaneously with its creation, correct?
Saw the document contemporaneously. We saw the document in final form at the meeting. We provided input. Usually what was done is we used the previous month's agenda and added various items to the agenda. We eventually worked out a whole system where my changes were shown in red and Mr. Solt's changes were shown in green. And then the final agenda was discussed at the meeting.
Okay, so this is a document that you're personally familiar with, correct?
Yes.
And you can personally authenticate this document as a true and correct copy of an agenda item, of a agenda for a site visit on October 27 and 28, 2015.
I'm not sure I'm a document authenticator, but it sure looks like the agenda that we had at that time, yes.
Okay, Mr. Chairman, I move the admission of this document as the next hearing exhibit.
Be hearing exhibit number 21.
I want to refer you, Mr. Jones, to page 5. Specifically, Roman numeral 6D. Can you read that into the record, please?
Discuss the status of the Bechtel assessment and the top 10 issues noted thus far.
That was your comment, your addition to this agenda item, wasn't it?
Yes, it was.
So you knew when you prepared this agenda item that Bechtel had done an assessment, right?
I knew that they had done an assessment, and I repeat, we did not know the scope, did not know the extent, did not know the findings. This item was put on the agenda as I would, when anyone talked to me about an assessment, if I didn't know what was going on, the first question I'd ask, well, what were the 10 top things that you found?
Okay.
That was the purpose of this item.
And then you actually discussed this agenda item at the site visit on those dates, right?
Very short discussion.
And the response you received at that time was that there was no written report available, right?
Correct? That's,
You didn't-
that's a response I received.
Okay.
And that was not true.
You believe that there was a written Bechtel report in existence in October of 2015.
There were written Bechtel summaries that had been delivered to the site. That is a written report.
In your view,
I would think that would be in anybody's view.
did you ask for written summaries of meetings?
No, because I didn't know to ask for written summaries of meetings.
Okay.
I asked for a written report, any written reports. Did not ask for a written report. I asked for the top 10 issues. What I was told was they identified nothing new. It was done at a high level. We don't know what came out of it, and we have been informed there is no written report and there will not be a written report.
And that was enough for you then, right?
It was, yes.
You didn't include it on the November site visit agenda, did you?
I did not, and I believed pretty much that if we weren't going to get it, we weren't going to get it. I would also like to just say, at this time there were bigger fish to fry at that time, and the bigger fish was we'd just gotten the October 5th or the October EPC amendment, and that occupied most of our interest at that time. There was a major change to the EPC contract that was going on. There were changes to the construction schedule, the whole terms and conditions of how things were going to be done. So that was what we were primarily interested in.
So you gaining more information related to the Bechtel assessment wasn't particularly important to you at the time because you knew the EPC amendment was about to be signed?
It wasn't particularly important to me because I trusted the people who told me there was nothing new and there would be no written report, and it was at a high level. And I can tell you my assumption was that this was executive to executive, and most of the time I don't really care about those. They are some kind of high-level advice, like you probably need to get a new senior vice president or something, and that. So, okay, if you're going to act on that, then it becomes important. If not, so what?
Okay. So whether or not you thought more information related to the Bechtel assessment was relevant at this time depends on what's actually conveyed in the assessment, right?
I did, and if you noticed in my chart, and it's on the chart over on the wall there, we've labeled this area the betrayal of trust. And that's exactly what happened, is I trusted that the information that had been provided by people who I'd been working with for years was true and represented the actual status. So,
And what you were told is that there was nothing new learned from the Bechtel assessment, right?
that's what I was told.
Okay. All right. Now, let's pull out the November site visit agenda, which is tab 8, Dan. Mr. Jones, are you familiar with this particular document?
Yes.
All right. And were you involved in the preparation of this site visit agenda?
Yes.
Okay. And were you the one responsible for removing the comment that existed previously about learning more information related to the Bechtel assessment?
I can honestly say I do not recall. One of my colleagues, Gene Solt, did some additional looking at this. And this was unusual. What he found from the record was that this item had been removed before we were given the draft agenda for the previous month. So can't specifically attest to it, but it appears that This was not removed by either one of us. It was taken off by SCE&G, and then the agenda presented to us for our comments.
But you had an opportunity to comment at that point. In the event you wanted to add an agenda item, you certainly could.
Certainly could.
Okay. So, Mr. Chairman, I'd like to move the admission of this document as the next hearing exhibit.
This will be hearing exhibit 22.
Okay. Mr. Jones, isn't it true that other than the October site visit agenda, you never put on any agenda throughout the life of the project gaining more information about the Bechtel assessment, right?
I wouldn't say that's strictly true. In our AIR 1-32, whose date I now don't remember, we asked for information on all the consultants that had been employed by SCE&G.
Okay.
Bechtel was not listed as one of those. We gave him a second chance to answer that question, and Bechtel still was not listed.
All right, we'll come back to that in just a second. Beyond this site visit agenda and the conversations that you recall specifically surrounding it, you testified in your deposition that you're aware of having conversations with 2 other SCE&G employees
Yes.
about the Bechtel assessment, right?
Yes, those were Alan Torres and Kyle Young. What I remember is we got the same story, that there was nothing new. It's a no, never mind. Don't have a written report, and that was it.
And you didn't ask Mr. Torres, for instance, whether Bechtel had produced a written assessment at the time that you discussed the Bechtel with him, did you?
I don't recall specifically what I asked, but I probably would not have asked Alan that, no.
Okay, so other than these specific conversations that you recall, you didn't ever directly ask anyone for a copy of Bechtel's assessment, did you?
Nope.
Let's talk about that ORS request 132 that you just mentioned. That's tab 9, Dan. This is the information request which you were referring earlier, right?
Yes.
Word Bechtel doesn't appear here anywhere, does it?
Does not.
You could have said, give me any written report provided by Bechtel Corporation, couldn't you?
We could have, but at this time we were looking for all consultants that had been engaged by SCE&G.
Well, that's not true at all. Look at the title of this document, Mr. Jones.
What title?
Title, South Carolina Electric and Gas Company, Office of Regulatory Staff's First Audit Information Request. October 15 amendments to the engineering, procurement, and construction contract related to the construction of a nuclear baseload generation facility at Jenkinsville, South Carolina, right?
Okay.
And then the request, so not only did the title refer to the October 15 amendment, Request 132 seeks specifically whether or not SCE&G decided to retain the services of a project consultant as allowed in the agreement. And the agreement there is the October 15 amendment to the EPC contract, isn't it?
No.
It is not.
No, it's the agreement in general.
As allowed in the agreement. It's your testimony here today that that is the original agreement, not the October 15 agreement that's identified in the title of this document.
The provisions of the October 15th amendment incorporate most of the provisions of the original agreement. So what's the point?
But you are aware, are you not, Mr. Jones, that Bechtel was hired before the amendment to the EPC agreement was executed, right?
Yes.
Okay. This is the only thing, the only request that you contend required production of the Bechtel report, isn't it?
Readily admit that we never asked for a copy of the Bechtel report.
Not a single additional request that you're relying on in providing your opinion to this commission, right?
Wow, no.
This is it.
Never asked for it. It's a no, never mind. Don't worry about it. Nothing new.
You certainly know And the ORS knows how to issue a written audit information request, right?
Do we know how to issue yes, we know that.
And the ORS issued them in 2016, didn't they?
Yes.
But there's not a single one asking for additional information related specifically to the Bechtel assessment.
Not a single one, no, sir.
Okay. And in fact, you submitted testimony to the Public Service Commission in 2016, didn't you?
Yes.
And that was in connection with SCE&G's petition for approval of the RISE cost and construction schedules related to the amendment, right?
Yes.
And you knew Bechtel was doing an assessment at this time.
Bechtel, what were you talking about?
By the time you submitted this testimony in 2016, you knew without a shadow of a doubt that Bechtel was had conducted an assessment.
They had conducted an assessment, and I go back to what I keep telling you. We had no idea what the scope, the extent, the results, or the recommendations were from that.
And the only instance in which you asked for any additional detail related to the Bechtel assessment, this detail that you say you didn't know, is this audit information request. Right?
Yes.
And you didn't, at the time you submitted this 2016 testimony, tell the commission that Bechtel had conducted an assessment of the project, did you?
No, I did not, because, again, nothing new, didn't know the scope, didn't know the recommendations, didn't know the extent of the assessment.
You didn't tell the commission any of that. You didn't say a word about a Bechtel assessment.
I didn't say a word about a lot of things. Why would I say something that I didn't believe was relevant?
That's right. As you told me in your deposition, if the Bechtel assessment wasn't significant, you didn't think anybody had an obligation to disclose it.
No, I didn't say that. I
Let's-
said we didn't have an obligation to expose.
Right, and you say you didn't have an obligation to disclose it because you didn't think it was significant.
No, I did not say that. I said we were told it was not significant.
Let's
It
look
wasn't a
at-
belief. It was a statement that was made to us that I believed.
Let's look at your deposition. We're going to try to get this on the screen. I have line numbers, but I am finding the page. Sorry for the delay. Mr. Chairman, I don't think this will take us very long, but do you want to take a short 5-minute break while we do this? Just to let people stretch legs? Up to you, Mr. Chairman. We're ready. Okay.
Go with it.
Start on line 9. Yeah, what page is that? 104. This is what you told me in your deposition. Page 104, line 9 and 10. Did you ever tell anyone at the commission about the assessment that you knew had been conducted on the site? You asked, by Bechtel? Yes, by Bechtel. No, is your answer. You didn't think you needed to provide that information, did you? I did not. I didn't think it was significant. So if it's not significant, information about the Bechtel assessment doesn't need to be provided to the commission, right?
The statement of it not being significant is based on my belief at the time that it was not significant because that is what I had been told.
Okay. Now, let's talk about some of the substance of the Bechtel assessment then. I'd like to show you the October 22 presentation. This is tab 10. I believe this is an exhibit to your testimony as well. Right, Mr. Jones?
Yes.
So you're aware now, aren't you, that Bechtel presented its preliminary findings to the owners on October 22, 2015, right?
Yes.
And that the presentation included a schedule assessment, right?
Yes.
And it's this schedule assessment that you claim one of the primary pieces of Bechtel's assessment that ORS was unaware of.
Yes.
Okay. Mr. Jones, you know Bechtel was only on site, on the project site, for 7 weeks, right?
I'm aware of the duration, yes.
And you know that Bechtel's entire assessment cost a flat fee of only $1 million.
Yes.
Right? How much money have you made associated with your work for the ORS since the inception of the project?
I have no idea.
Is somewhere around $900,000 about right?
I don't know.
Does that sound in the ballpark?
I don't know.
Is it significantly less than that?
I don't know.
Is it in excess of $500,000?
I'm telling you, I don't know. I've never multiplied it out.
So you don't know how it compares to the $1 million that was paid to Bechtel to do an assessment of the project, do you?
No, and I don't see any relevance to that at all.
Okay. So the schedule that Bechtel presented to the owners was couched by Bechtel as preliminary, wasn't it? It's on page 24 of this presentation.
Yes.
Also, the whole document indicates that it's a draft, right?
Yes.
And then you've reviewed this document, so you're familiar with the fact that Bechtel says in this document that many documents they received when performing the assessment were redacted, right? Look at page 6.
Don't recall that explicitly, but if it's on page 6, I will look.
It says many documents were redacted, right?
Okay.
It also says the manner in which other documents were provided limited Bechtel's ability to fully assess the information, correct?
Yes.
Okay. And then you're familiar with the fact that Bechtel itself, in this presentation, said a more robust approach is needed prior to finalization of any changes to the baseline target schedule. Are you familiar with that fact?
Yeah. This was not a schedule to build the plant to. You don't build the plant just to this. This was an assessment of the schedule, not a schedule to construct the plant, and it should be not confused with that. But what it did do was give an opinion of a reputable and experienced contractor, and it should have been further investigated.
And you agreed?
They say that it should have been further investigated, and it was not.
You agreed with me during your deposition that if the information Bechtel provided regarding the project schedule forecast was unreliable, it wouldn't require any change of course on the owner's part, right?
If it was determined that it was totally unreliable, I would agree with you. Just because somebody says it is doesn't mean that it's so.
All right. So at bottom here, you think Bechtel raised questions regarding the likelihood of SCE&G meeting the construction schedule for the project, right?
Yes.
And you yourself, or I should say, but you yourself had those concerns regarding the schedule, right?
I had some concerns regarding the schedule, and frankly, most were somewhat ameliorated by the fact that the fixed price EPC contract was made.
That's right. But let's make clear just how much information you had and the level of concern you had regarding the schedule. Let's look at tab 11.
What's tab 11? Oh,
Ms. Wilson handed it to you. It's a document I showed you during your deposition, Mr. Jones. This is an email from you to Brittany Waring. You're familiar with this document, aren't you?
yes.
The very first sentence that you write to Ms. Waring is, please see that Dukes gets this. See that?
Yes.
That's Dukes Scott, correct?
Correct.
All right. So you recall preparing the email and then the attachment to the email, which is a summary of June 2016 VCS 2 and 3 site visit and recommendations, correct?
Yes.
Okay. Paragraph 4, or excuse me, sorry, page 4. You indicate that you have no confidence that the budget cited by SCE&G in their filing represents the final costs of the project. Right?
Yes.
That's what you knew in 2016. Right?
What I would say was that was my opinion.
Well, you formed that opinion in part, as you note just in this paragraph, based on SCE&G's filing. Let's go to, I'm sorry, look at page 4, paragraph 4. You read that into the record, Mr. Jones?
Whole paragraph?
Nope.
What?
First sentence.
I have no confidence that the budget cited by SCE&G in their filing represents the final cost of the project, and neither do they as stated in their filing.
So it was clear to you from the filing itself, these concerns related to the confidence in the final cost of the project, right?
I'm sorry, repeat that.
It was clear to you from the filings SCE&G made that they had significant concerns related to the budget for the
yes.
completion of the project.
Yes, there were concerns related to the budget.
Okay. And you'd separately concluded in paragraph 3 of this note that you had no confidence in the schedule.
Correct.
So you knew what you believe Bechtel conveyed in its assessment, right?
No, that's not correct. If you read the paragraph, I still believe that the schedule for Unit 2 could be met within the 18-month window allowed by the PSC, and then the unit could qualify for production tax credit. So I had some, I would now call it displaced hope, that the schedule could be met.
You told Mr. Scott, Duke Scott, who was the executive director of the ORS, in the very first sentence of paragraph 3, I have no confidence that the stated completion schedules will be met. That's what you said, right?
Correct.
That's what you believed then.
You have to modify it with it was still within the 18-month window allowed by the PSC, however. I have no confidence they were going to meet what they said.
Okay. I'd like to move the admission of this particular document as the next hearing exhibit.
Hearing exhibit number 23.
Now, Mr. Jones, you submitted testimony to the PSC in 2016, as we discussed a little bit earlier, right?
Right.
And that was filed in October of 2016, correct?
Don't remember the exact date, but if that's what it says.
Okay. Well, this is the first page of it. Does this look familiar to you?
Yes.
Okay. Mr. Chairman, I won't move the admission of this document. It's my understanding that this testimony would already be a part of the record in this proceeding. Is that correct? Okay, fair enough. I'm happy to show Mr. Jones a copy of it so that we can do so. Oh. It's tab 12. Okay. We'll clean. That's a housekeeping matter. We apparently don't have copies of this. I don't need Mr. Jones to talk about specific language in the testimony, but we'll provide copies and move for the admission of it if and when it becomes appropriate. Okay. But you do recall, don't you, Mr. Jones, that in 2016 you recommended approval of SCE&G's schedule, right?
I recommended that their filing be approved, subject to the settlement agreement that had been made.
That's true, even though you had no confidence in it, correct?
I had no confidence in the ability of them to meet the exact schedule. Again, I thought that they would be within 18 months of Unit 2 at that time, and that a big driver on this was the issue was somewhat moot from the standpoint that with the settlement agreement, they had a fixed price of the contract. Schedule became not too relevant to the ratepayers of South Carolina, and cost, in essence, became somewhat irrelevant because the costs were going to be borne above and beyond what SCE&G had filed. All those costs were going to be borne by Westinghouse, if not by Westinghouse, by Toshiba, and if not by Toshiba, by SCE&G, according to the settlement agreement.
So in 2016, you decided you didn't need to tell the commission about your lack of all confidence in the schedule because you thought the fixed price option and the exercise of the fixed price option made schedule concerns and cost concerns largely moot.
I would say that's probably the case.
Okay.
Again, I thought that they could make the schedule if they had the improvements implemented. They could make the 18-month window on Unit 2 if they made the improvement.
You're also aware now, Mr. Jones, that the owners received a final report from Bechtel on February 5, 2016, correct?
So aware during this discovery process.
That's right. In that final report, at least what SCE&G employees received didn't include the schedule assessment, did it?
I don't know what they received. What I know is that there was a separate special report pulled off that addressed the schedule, and I received it even later than I received the February, whatever the heck it was, report.
First, okay, good. So you're aware, are you not, that Ty Troutman, the president of Bechtel Power Corporation, testified that Bechtel never sent to any SCE&G employee any of the written reports? You've seen that in his testimony, haven't you?
Don't recall that specifically. May have. Don't remember.
Have you? Are you also familiar with the fact that the law firm that engaged Bechtel didn't provide the schedule assessment report to SCE&G?
Not aware of that. Don't know anything about it.
All right. In any event, as to the findings that are contained in this particular report, you've agreed, haven't you, that Bechtel didn't identify any new issues of the project associated with the project of which you were unaware, right?
No, not fully. I admit that the issues themselves, most of the major issues they identified were known to me. There's some scattered throughout there, and some of those that deal with startup activities and those kinds of things that weren't necessarily known to me.
So the ORS
But
did
the issue is not the issue. Knowing the issues doesn't get you much of anywhere.
Is that because you need to know proposed ways of resolving them?
That helps a lot.
Okay. So let's talk about that. So you just want to make sure the record's clear. You never argued in this proceeding that most of the issues, excuse me, let me say this a little bit more precisely. You have never argued the assertion that most of the issues that Bechtel identified were in fact known by ORS.
I have not. I have agreed that most of the issues were known by the ORS. Yes.
All right. And as you sit here today, you're not aware of Bechtel having more information regarding the status of the project than you had in 2015, right?
I can't answer that question. I don't know precisely what information Bechtel had.
Well, I asked you during your deposition if you were aware now, and are you aware then, or are you aware now of Bechtel having more information than you did?
I can answer the awareness question, and the answer to that is no, I'm not aware. That doesn't mean they had it or didn't have it.
And in fact, as I think you already told the commission today, Mr. Jones, you know that SCE&G actually implemented or was in the process of implementing most of Bechtel's recommendations, right?
Yes, the issue that is somewhat galling is we didn't know they were Bechtel recommendations.
But you knew the recommendations were being implemented by SCE&G.
We were aware of, I think, most of the implementation plans that were there. But I think it is important to recognize that, you know, I don't see how you classify an assessment as useless when you specifically track the recommendations of the organization that made it.
Couldn't it be because they were already known and in the process of being implemented?
Why would you track that Bechtel had made them then?
Okay, so the information that you believe is so critical to have been disclosed is the fact that Bechtel had made recommendations that you knew to already be ongoing at the site.
The most critical information that wasn't conveyed was the Bechtel schedule assessment. I will say that for the 1,000th time. That's the most critical information. Now, why was non-disclosure of the Bechtel recommendations? Okay, one reason I can tell you is the misperception that the ORS team got that, hallelujah, SCE&G has finally recognized what they need to do and they've started implementing this stuff.
Okay, so let's move on to the 2015 PSC filing. This is the second basis for your opinion that the PSC should disallow recovery of costs incurred after that 2015 filing. You specifically say that the ORS should have received additional information related to SCE&G's 2015, specifically connecting to SCE&G's schedule and cost estimates, right?
I'm sorry, where are you?
I'm just trying to set the stage. So you're talking about the basis for you objecting to cost post March 12, 2015. And one of those bases is that you believe the ORS should have had more information related to SCE&G's schedule and cost estimates, right?
I would say what we should have had was the results of the EAC estimate, which were generated by SCE&G themselves.
The EAC isn't a schedule, though, is it?
It's a cost.
Right. So is it your testimony that you had all the information you could want related to the schedule?
No, what we didn't have relative to the schedule is that to SCE&G, it didn't represent a true and actual schedule of the project. They had no confidence in it, and it was not conveyed to us. Therefore, that's what the information that we should have been provided is that they had no confidence in the schedule. And it wasn't just that it was challenging, as was stated in testimony, and it wasn't just that new heights would have to be achieved on productivity factors. It was that they believed it was unattainable.
Yep. So that's your testimony. But you admit, do you not, that Mr. Byrne testified to the commission in 2015 that the schedules for the project can and almost certainly will change?
I'm not going to admit that. That's what Mr. Burns testified.
Right. He said that to the commission.
Yes, it was in his
in 2015.
Yes.
And you also submitted draft testimony in 2015, you drafted testimony in 2015 to submit to the PSC before the settlement between the ORS and SCE&G was entered, right?
Yes.
Okay, so let's look at that. That's tab 15.
Mr. Challey,
Yes, sir.
since we've got a good bit more to go, So it's reached the 4:30 hour. We're going to adjourn and start back over Monday morning at 9 a.m.
Thank you.
Mr. Chairman, before we adjourn, may we have an instruction that the witness remains under cross-examination and may not confer with counsel or staff over the weekend?
Yes.